This trial is a culmination of decisions made by one person.
Right from the start, the judge frames this as something bigger than a crash. This isn't about an accident, it's about choice. And in criminal law, choice is everything, because intent separates tragedy from murder. Ask yourself, was this recklessness or was this design?
Defendant. Those decisions have forever altered the futures of 3 families, and of you also, Mackenzie. And your decisions forever robbed Dominic and Davion of the futures that they had before them.
This is where the emotional gravity lands. In homicide cases, courts often shift focus from the defendant to the victim's stolen futures. It humanizes the legal argument, because beyond statutes and sections, these were young lives with birthdays, careers, weddings, now permanently erased.
If there is one thing that can be taken away from this case, as painful as it is this. Every decision we make is important. Every action we make is important. Regardless of whether the decision is a good one or a bad one, or the actions are good or not, the result is the same. The consequences ripple through time and affect many more people than one might think at the time of the decision. In criminal cases, the state carries the greatest burden under our law, proof beyond a reasonable doubt.
This is the highest burden in our legal system. Not probably, not most likely. Beyond a reasonable doubt, that means the judge had to be morally certain. If there's a reasonable alternative explanation, the defendant walks. So what evidence convinced the court there was no doubt?
As I previously stated, I considered all the evidence presented. And at this point, I would like to comment specifically on Exhibit 802, the crash video.
Here it comes, the prosecution's nuclear evidence, video footage. In modern trials, video doesn't just support testimony, it dominates it. Jurors, and in this case, the judge, don't just hear what happened, they see it. And once you see something like this, you can't unsee it.
This is the type of evidence you can never unsee. You can never forget the visual or audio of this exhibit. It is chilling and tragic. As you review that exhibit, you know that you are watching the oncoming deaths of 2 people, and there is nothing that will stop it. The video clearly shows the purpose and intent of the defendant. She chose a course of death and destruction that day.
So notice the language, chose, course, intent. The judge is dismantling any argument of panic, loss of control, or momentary recklessness. This is methodical framing. Legally speaking, that's how you elevate a case from vehicular homicide to murder.
Exhibit 802 crystallizes the deadly decision-making of the defendant. She morphs from a responsible driver to literal hell on wheels as she makes her way down the street. Mackenzie alone made the decision to drive the car, to drive an obscure route, a route she visited a few days before, and a route not routinely taken by her. Mackenzie alone chose the time to make the drive, early in the morning, when any reasonable person would expect that few people would be nearby to witness it or offer life-saving assistance. She made these decisions despite knowing, as any reasonable person would, that her mission of death could have involved others, not even in the car with her, other people, other cars, pedestrians. She had a mission, and she executed it with precision. The mission was death. Mackenzie alone decided to push the pedal to the floor and demand the ultimate speed of that vehicle to 90 to 100 miles per hour. She alone decided what was to be. Mackenzie decided death was the ultimate goal that day. And she alone made that decision for Dominic and Davion, and she continuously acted in a manner to achieve her purpose. Whether or not she intended to also kill herself is a matter of speculation that have no relevance to the weighing of the evidence in this case. The totality of the evidence clearly demonstrates that Mackenzie Shirilla acted purposely and intentionally in the early morning hours of July 31st, 2022, and her purpose was to kill Dominic Russo and Davion Flanagan. No reasonable fact finder could view the totality of this evidence in this case and come to any other conclusion. Her actions were controlled, methodical, deliberate, intentional, and purposeful. This was not reckless driving. This was murder.
And that right there is the turning point. Reckless driving implies stupidity. Murder implies purpose. That single distinction carries a life sentence's weight. When a judge says those 4 words, "This was murder," the courtroom air changes. You can almost feel it.
Court renders the following verdicts.
Now comes the formal verdict reading. And this is where the legal machine takes over. Count by count, statute by statute. Each guilty finding stacks like bricks in a wall the defendant cannot climb over.
Count 3, murder. The court, having had count 3 tried to and pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of murder, to wit Dominic Russo, in violation of Ohio Revised Code Section 2903.02b as charged in count 3. Count 4, murder. The court, having had count 4 tried to and pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of murder, to wit Dominic Russo, in violation of Ohio Revised Code Section 2903.02b as charged in count 4. Count 5, felonious assault. The court, having had count 5 tried to and pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of felonious assault, to wit Dominic Russo, in violation of Ohio Revised Code Section 2903.11 of the Revised Code, is charged in count 5 of the indictment. Count 6, felonious assault. The court, having had count 6 tried to and pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of felonious assault, to wit Dominic Russo, in violation of Ohio Revised Code Section 2903.11a2 as charged in count 6. Count 7, felonious assault. The court, having had count 7 tried to and pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of felonious assault, to wit Davion Flanagan, in violation of Ohio Revised Code Section 2903.11a1 as charged in count 7. Count 8, felonious assault. The court, having had count 8 tried to and pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of felonious assault, to wit Davion Flanagan, in violation of Ohio Revised Code Section 2903.11a2 as charged in count 8. Count 9, aggravated vehicular homicide. The court, having had count 9 tried to and pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of aggravated vehicular homicide, to wit Dominic Russo, in violation of Ohio Revised Code Section 2903.06a2a as charged in count 9. Count 10, aggravated vehicular homicide. The court, having had count 10 tried to and pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of aggravated vehicular homicide, to wit Davion Flanagan, in violation of Ohio Revised Code Section.
At this stage, it's overwhelming. Multiple murder counts, felonious assault, aggravated vehicular homicide, drug possession, possessing criminal tools. This isn't a single bad decision. The court is outlining a pattern, one that paints intent from multiple legal angles. Each count reinforces the narrative the judge already made clear.
2903.06a2a is charged in count 10. Count 11, drug possession. The court, having had count 11 tried to and pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of drug possession in violation of Ohio Revised Code Section 2925.11a as charged in count 11. Count 12, possessing criminal tools. The court, having had count 12 tried to and pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of possessing criminal tools in violation of Ohio Revised Code Section 2923.24a is charged in count 12. The court, having had count 12 tried to and pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of possessing criminal tools, and further finds the defendant did intend to use a substance, device, instrument, or article, to wit, a digital scale, to commit the offense of a felony. Sentencing will be 1 week from today.
And now we enter the final chapter, sentencing. The verdict determines guilt. Sentencing determines fate. Will the court impose consecutive life terms? Will there be any mitigation considered? That hearing will decide how long this story echoes in prison walls. Intro. 2 families leave this courtroom without their sons. One defendant leaves facing decades, potentially life, behind bars. The law delivered its answer. But the question that lingers is deeper. At what moment did this become irreversible? Let me know in the comments. Was this clearly intentional from the start, or did the video change everything for you?
August 21st at 1 p.m. If any party wishes to file a sentencing memorandum, it is to be filed by 4 p.m. on Thursday, August 17th. Thank you.
Thank you.
Love you, baby.
Everybody drinks this way.